Rick, I have a question to ask you.
Yes, ma'am.
In each session, for instance, like this one, are we going to receive a certificate for accomplishment in each session or one whole session
Yeah.
certificate?
Daisy, man, that's a great question. I'm gonna ping that back over to Denise.
So we are definitely able to provide what it would be is a virtual certificate because it's a virtual training. So we could email you a PDF copy of that certificate if you'd like.
Yes, I would appreciate it. It's good for our record.
Just writing that down. So I'm gonna go ahead and mute all, just letting everybody know. And then we're gonna go ahead and get started. Okay. Good afternoon, everybody. Thank you for joining us for our first Q&A webinar of 2023. This webinar is going to provide an overview of tribal councils acting in the capacity of tribal courts. My name is Denise Nerby. I serve as the training manager for the Community Services Division at AVCP. As we all continue to do our best in keeping our families and our communities safe, our division continues to do our best to provide our services to you in different ways. With this being said, I would like to go over some housekeeping items. This training is being recorded for future viewing and will be available on the AVCP YouTube page. Since we are in a virtual environment, to start off, everyone is muted. To be able to unmute yourself, please press *6 or the little microphone button at the top right-hand side of your screen. I would like to ask that everybody keep your phones or computer microphones muted at all times unless speaking. And please do not place this call on hold because doing so enables the hold music functions even if you're muted. There's an available chat feature for participants joining through the online app that will be monitored for questions. But also we're going to provide a Q&A session at the end of Rick's presentation. And if any questions in the chat are missed, we will ask them during the Q&A session. At this time, I will ask that you join me in saying the Lord's Prayer. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, and deliver us from evil. For thine is the kingdom, the power, and the glory forever and ever. Amen. Now, I would like to take the time to introduce today's presenter. Rick Garcia serves as the co-director of law and policy for the Alaska Native Women's Resource Center. Rick moved from Florida, where he was raised, to Alaska in 2018 and has dedicated himself to serving Alaska tribes, tribal courts, and tribal justice systems. Rick, I would love to hand the time over to you.
Awesome. Thanks, Denise. I'm gonna go ahead and share my screen. I want to make sure that we can see. Can everybody see the screen?
I can see it.
Okay, perfect. Well, thanks for that, Denise, and I really want to thank everyone for joining me today. So today we're going to talk about tribal councils as tribal courts. And so we're going to talk a little bit about the authority for tribal councils to act as tribal courts. We're going to touch upon some ethics considerations that come into play when tribal councils act as tribal courts, and also talk about some best practices. Like Denise mentioned, my name is Rick Garcia. My Yupik name that was given to me by Alvin Jimmy is Nagakak. My mom is from South Korea, and my dad is indigenous from Mexico. I was born in Germany and raised in Miami, Florida, and I moved to Alaska in 2018. Since that time, I've really dedicated my work to supporting tribal courts, tribal justice systems, and tribes in different aspects of tribal court development, and really helping tribes to establish tribal courts or reinvigorate the tribal courts to handle these issues at the local tribal level. So we're not running to the state court for assistance. If anybody has any questions throughout the presentation, please feel free to interrupt me or put them in the chat. And if I start to talk really quickly, I generally tend to get really excited when I'm talking about these things. Please just raise your hand or interrupt me and ask me to slow down. But as Denise mentioned, currently I serve as the co-director of law and policy for the Alaska Native Women's Resource Center, which is based in Fairbanks, but I'm located here in Anchorage on the home of the Dena'ina people. So I wanted to start off by sharing a little bit about the Alaska Native Women's Resource Center and what we do. And so since 2015, AKNWRC has really been dedicated to strengthening local tribal governments' responses to domestic violence, to family violence, gender-based violence, intimate partner violence. And we do that through community efforts that really advocate for the safety of women and children in their communities and homes. And so at the Resource Center, we do that through a number of different ways. So both myself and Kendra Kloster, who is joining me today, are the co-directors of law and policy. And so the law and policy team really advocates, reviews policies, both federal, state, and tribal policies that affect tribal communities, tribal justice systems, victim and survivor services programs at the tribal level, to really identify and uplift those priorities that are specific to Alaska to our federal and state congressional delegation, as well as partner with a lot of nationwide organizations to really, again, make sure that Alaska is part of that conversation. The other aspect of what our department does is what we're seeing today. We do a lot of tribal justice and tribal court trainings around the state. And I've got to say, you know, I'm always thankful when Denise and Roxanne and my AVCP family reach out to us to allow for us to present. You know, when I first moved to Alaska, I landed in Bethel for 2 years, and it was, I mean, it was a great experience. The AVCP family and the community of Bethel really welcomed me with open arms. So I always feel really grateful and excited when I'm able to provide some assistance to the AVCP region and the region tribes. But the other side of AKNWRC, we have two different teams. We have a technical assistance teams that really helps tribes to develop and sustain their victim services programming. A lot of our staff have years and years and years of experience with developing and managing and administering victim services programs through many different types of grants, such as OVC, OVW, through the Tribal Victim Services Set-Aside Grants funding, through FIPSA funding. And so that side of the Resource Center really helps tribes develop and support programs that support victim services at the tribal level. And the last section of AKNWRC is grants management. We have a great grants management team that is really experienced in all facets of grants administration, from pre-grant award assistance to post-grant award assistance, including reporting, how to fill out those annoying annual or biannual reports, and post-award closeouts when tribes have their awards that are ending, and how to really support that in that process. So if we can help in any way, please feel free to reach out to me. I'm always happy to connect you with who at our team can do that. But we always are able to support tribes and tribal organizations statewide. And the best part about it is that all of our services are free of charge to a tribe. Okay, so on to the presentation. I always like to start presentations by providing a roadmap of what we're going to talk about today. So today we're going to touch upon Alaska tribal sovereignty and talk about tribal justice systems in Alaska. We're going to move on to talking about who can act on behalf of a tribal court. So that's going to really look at the authority of tribal councils to act as tribal courts. We're going to talk a little bit about the different types of tribal court structures and what we're seeing today in Alaska, how tribes are organizing and establishing and administering their tribal justice systems. And then we're going to move into talking about more specifically about tribal councils acting as tribal courts. And so when we talk about tribal councils acting as tribal courts, there are certain requirements by federal law that we need to be aware of. And there's also some considerations that we want to talk about. We're going to talk briefly about judges' code of conduct and ethics and how that plays into tribal councils acting as tribal courts. And then finally, we're going to follow up with best practices and final thoughts in closing. Okay, so I always like to start off with this quote. And so the quote is from Felix Cohen, who was a United States solicitor with the United States Department of the Interior in the early 1930s. and who is considered to be really the leader and the father of Indian federal Indian law in the United States. Felix Cohen was a primary legal architect of legislation that was creating the Indian Reorganization Act. And in 1939, he became the chief of the Indian Law Survey, which was the first of its kind in the United States. And it was an effort really to compile all the different federal laws and all the different federal treaties regarding American Indians. And so the result of that long survey of Indian law and treaties surrounding American Indians and Alaska Natives in the United States was a book that was published in 1941, known as the Handbook of Federal Indian Law. And so the handbook is really considered the book on federal Indian law. It's been updated since Felix Cohen's times, but it really is the go-to for those in the legal profession to understand, to interpret, and to really get background on federal Indian law. And so when we think about and we talk about tribal authority, again, I like to start off with this quote because, and I'm just going to read it from the screen, but he says, perhaps the most basic principles of all Indian law supported by a wide host of decisions is this principle that Indian powers, which are lawfully vested in an Indian tribe, are not delegated powers granted by express acts of Congress, but are rather inherent powers of a limited sovereignty, which have never been extinguished. And so we always like to start with this framework because we know that Alaska Native and American Indian tribes have been providing services. They are sovereign since time immemorial. And so when we think about the Indian tribes and Alaska Native tribes as sovereigns, they're on the same level as, let's say, the United States, as Canada, as Mexico in North America, and as all different other countries that enjoy that status as sovereignty, as a sovereign. And so we start by that the tribal powers of Alaska Native and American Indian tribes are inherent powers. And that means that they were not given by anyone. So they were not given by the United States. They were not given by Congress. Although Congress does have the ability to limit those powers, limit the sovereignty of tribes, but we always like to start with the notion and the belief and the fact that tribes have a sovereignty basis, and they have inherent powers to govern over tribal affairs, to govern over their tribal citizens, and other American Indian and Alaska Natives. So when we talk about tribal sovereignty, and we'll probably use these words interchangeably, sovereignty and authority, but tribal sovereignty at its very base level, it refers to the authority or the jurisdiction of Alaska Native and Native American tribes to govern themselves within their own territories or villages and to make decisions that are related to their own affairs without interference from outside governments or entities. And so, again, tribal sovereignty is rooted in the history of the Native American and Alaska Native tribes and that unique government-to-government relationship with the United States government. And so when we think about, again, that sovereignty and those inherent powers, in the late 18th century, the United States government began signing treaties with Native American tribes that recognized their sovereignty. And back then, they promised to respect the rights of self-government, self-determination, and self-preservation. And so when we think about tribal sovereignty today, what we're seeing in the latter part of the 20th century and now in the 21st century, is that right? I think those are the right centuries. But we're seeing that federal Indian law and various court decisions are starting to uplift tribal sovereignty. There was a period known as the termination era that were trying to the United States governments were trying to terminate tribes. They were severely limiting tribal sovereignty through various federal acts, through acts of Congress and different laws. But we are seeing an uptick. We are seeing a reclamation of tribal sovereignty in the late 2000s, late 1900s and early 2000s. And so, as I mentioned, tribal sovereignty is not absolute, and there are limits to the powers that tribe can exercise within their villages here in Alaska. And again, that is governed and that is detailed and that is done through acts of Congress or through our Supreme Court that is interpreting certain laws and cases that come to them. But when we think about tribal sovereignty and we think about tribal governments, tribal sovereignty allows for tribal governments to have that power to regulate activities within their villages and regarding their tribal citizens. And that power includes the power to establish governments, to determine citizenships, to make and enforce your own laws, to govern, protect, and enhance the health, safety, and welfare of your citizens within your jurisdiction, to regulate activities on tribal lands, again, to govern the affairs of the tribe, and to really do justice. And so when we say do justice, we're talking about the ability of tribes and the sovereignty, inherent authority of tribes to establish not only tribal councils, to establish tribal courts, justice systems, and those types of internal systems that administer justice on behalf of tribal citizens. So what does the Alaska Supreme Court say on tribal justice systems? So in a case, John v. Baker, which rose to the Alaska Supreme Court in 1999, the Alaska Supreme Court, again, they reaffirmed the inherent authority, the inherent sovereignty of tribes to, and they stated that tribes have the power to make their own substantive law in internal matters and to enforce that law into their own forums. And again, they went on to talk about that tribal sovereignty is valuable because it really enables Native Americans and Alaskan Natives to control their own internal relations and to preserve their own unique customs and social order. So when we go back to, again, the tribal sovereignty, that inherent sovereignty, the fact that tribes come to the table when we're interacting with the United States as a sovereign, the Alaska Supreme Court, again, recognized in 1989 that, again, tribes have that power to govern their own affairs, to make their own law, to handle their own justice systems in the manner that they seem fit, in the manner that is culturally appropriate and works best for each of their communities. So when we think about tribal justice systems, and tribal justice systems and tribal courts are going to be interchangeable throughout their presentation, but when we think about the justice systems of tribal courts, they really serve as a fundamental expression of the tribe, again, as a sovereign. And the reason why that is because tribal courts have the ability to administer justice, and that justice is going to depend on how tribes are establishing their laws, what is written in the codes, what kind of unwritten and customary law they implement within their jurisdiction and within their villages. But tribes really serve as that essential component of the immediate and long-term process of really holding your citizens and sometimes your non-Indian offenders accountable for the behavior within your tribal communities. And so having a court or having a tribal justice system it serves to increase and really strengthen your tribe's response to violence, to other crimes, and really to increase that response to expectations of behavior that you have about your tribal citizens and about those who comes to your villages. And so your tribal court or your justice systems can really provide that local, culturally based, holistic responses to address concerns and really provide a pathway to not only individual healing, but also to healing of the community as a whole. And so when we think about, again, the expression of establishing courts or justice systems, that is really only given to sovereigns. So when we think about in Alaska, the state of Alaska as a sovereign has the ability to establish district courts within the state of Alaska. That can only be done by the state of Alaska. In the same manner, tribes in Alaska, tribes are the only ones who can establish tribal courts within your tribal communities and your villages. So it's a great power, again, that comes since time immemorial and is really possessed because of the tribe status as a sovereign. So when we think about tribal courts and how they're organized, we're going to go into detail a little bit later and talking about not only the different types of tribal court structures, but also looking at how tribes in Alaska are utilizing the tribal courts and what types of cases they're hearing. But tribal courts are really organized based on the needs of the community. And so what I mean by that is that tribal communities have a choice on how to respond to violence. They have a choice on how to respond to behaviors and how to hold offenders accountable. And so when we think about the needs of the community, tribes have the authority to decide really how to organize their government response through their tribal courts or through their tribal justice systems. And so on the screen, I provided just a couple examples of different tribes So we know that the native village of Anvik, and so really relevant to today's conversation is in Anvik, their tribal council acts as a tribal court. By comparison, in Tlingit Haida, the Central Council of Tlingit Haida Indian Tribes of Alaska, they actually have a separate and distinct tribal court, and that should be here, excuse me, that utilizes that tribal court to hear and decide cases. When we're looking at another tribe in Southeast, the organized village of Cake, they don't use a tribal council. They're not using a tribal court in the Western model, ideology, but what they utilize is a traditional peacemaking circles that really involves people of the community that's been harmed, the offender, the victim, and they bring them all together to use that traditional and cultural peacemaking circles that Alaska tribes, again, have been using since time immemorial to really organize their tribal justice system. So as you can see, again, they're organized based on the needs of community. There's lots of different considerations that go into whether or not we're going to have a separate tribal court, whether or not the tribal council is going to act as a tribal court, whether or not we have maybe an elders panel that we're using as tribal court judges. And some of those considerations deal with funding, of course. We know that funding in Alaska is challenging. It has to deal with human capacity. Does the tribe have enough people that can sustain two separate branches of government, the tribal council and the tribal court? So there's lots of different considerations, but I wanted to kind of highlight three different tribes in Alaska and how they're all administering their tribal justice systems a little bit differently. So how are tribal court or justice systems established? Excuse me. So a tribe's authority to do everything on behalf of their tribal citizens, including established courts and justice systems, that is derived from your tribal constitution. And so the next two slides is going to provide just some examples of some different tribal constitutions and show you the authority of the council to establish either tribal courts, tribal justice systems, peacemaking circles, again, whatever is going to fit to benefit your community at that time. And so you see here, this is a blurb from a section from the Gakona Tribal Council, Article 9. And if you see there in section 3, Tribal Council Powers, it says, in addition to all powers vested in the tribe or council, the tribe acting through the council shall have the following powers. And the power that they have, one of them is to provide for the maintenance of law and order, health and safety, protection of children, and the administration of justice, which includes establishing appropriate tribal courts or other judicial bodies. So Gakona has it spelled out right in section 3 that the power of the tribal council includes the power to administer justice or the power to do justice, and it gives the tribal council to either establish tribal courts, other judicial bodies, or both. By contrast, so we're seeing here, this is ONC's tribal constitution. Their powers, which is in Article 6, Section A, Section 1, you'll see it's pretty similar to Gakona's, but it says, except as otherwise provided in this constitution, all powers of the ONC tribe shall be vested in the ONC, and it allows them to enact laws establishing and governing a justice system, which includes setting up an independent tribal court or other conflict resolution mechanism and law enforcement. So here you see in ONC's tribal constitution, it allows them to not only set up a justice system or tribal court or something other conflict resolution mechanism, but it also allows the council to establish a completely separate body of the tribal government, which is that independent tribal court. And an independent tribal court is going to be one where a tribal council is not acting as a tribal court, but where the tribal court is a separate and distinct branch of the tribal government, which is going to be different from your tribal council. And the easiest way to kind of analogize that to the Western model is in the United States government, we have the executive, who is the president, who has his own powers. We have the legislative, who is Congress, who has the power to make laws and pass laws. And then we have the Supreme Court, which has the authority to interpret laws, to establish other courts throughout the country. And so there are really three distinct independent branches of government. And so that's what ONC is talking about in section G there. So, tribal court and justice systems options. There are many, infinite ways that tribes can set up their court and justice system options. And again, how they set up or how tribes are setting up their tribal court or their tribal justice system, it depends on really meeting what kind of format or what kind of system is going to meet the needs of our community. And so we see in Alaska, we see single judge panels. And so that's where one judge is going to be hearing all of that tribe's cases. And so we generally see that in communities that are much smaller or communities that have a little bit more difficult time finding people to serve on tribal councils and all different aspects of tribal government, as well as the tribal courts. The benefit of a single judge, again, is one person is hearing those cases. One person makes the decision. And again, we see those more often in smaller communities. The second type of justice and court structure is a panel of judges. And that's where, two or more people will serve as a tribal court judge. They will both or all of them will hear the same case. The decision for the cases are generally made by consensus. And so generally speaking, we see a panel of 3 or more, with an emphasis really on being on those odd numbers, so 3, 5, or 7. So the decision will be something that can be forwarded to the parties to the case. When you have judges that are either 2, 4, or 6, or some even number, you can oftentimes result in some type of deadlock where it's completely even amongst the sides. And so what we're seeing in the panel of judges is oftentimes in odd numbers. And so we see panel of judges in tribal communities that are sometimes larger. We see a panel of judges in tribal communities that understand that a single judge may be overwhelmed, or they have a few people who are interested in being tribal court judges. I would say that the panel of judges is the type of tribal court and justice system option that we see most frequently in Alaska. We see visiting or traveling judges, and so that is really helpful when we have a community who wants to host a tribal court within their village and their community, but maybe doesn't have the human capacity or hasn't identified judges yet. And so we'll see that oftentimes we'll ask our neighboring tribe, can we borrow your judges to come hear this case? And in that situation, the traveling or visiting judges will come to the community. They'll hear the case in the neighboring village, applying that village's laws and procedures, but they will just act as that medium, as that person who's going to be deciding that case on behalf of the neighboring tribe using their laws. We also see court and justice systems that are specialty courts. And so that means that they are just focusing their efforts in their tribal justice or tribal court systems maybe on 1 or 2 types of cases or maybe more. So they're limiting that jurisdiction currently to hear, let's say, child welfare cases, child protection cases, ICWA transfer jurisdiction cases from state court to tribal court, or some kind of focus area for their courts. We also see intertribal courts, and this is super helpful. I know that the ABCP region has one in Kotlik currently, and I think one is being developed in the Kungiganac area. But in intertribal court, it really is 2 or more tribes that are sharing resources. They may be sharing professional services, such as maybe a tribal court clerk, and usually by way of some type of intertribal agreements. And so the benefit of an intertribal or regional court is that you can pull your resources together, including funding, including projects, equipment, and also that human capacity or that human personnel. But each member tribe retains its own laws, retains its own rules, values, and also decides which types of justice services it wants to exercise, whether that be criminal, civil, family, children. And so what we're seeing in tribal court, intertribal courts or regional courts, we're seeing that is an option. Sometimes it's the only option for a tribe. Sometimes tribes will also have their own tribal court or justice systems at their level, and they're choosing to use that intertribal or regional court as an appellate court, as a conflict court if their judges are conflicted out, and things like that. We're seeing elders panels. A lot of tribes are drawing from that historical and customary practice of including elders, letting elders decide. And so we're not seeing tribal court judges, but we're seeing a panel of elders who are sharing that wisdom, who are sharing that experience with people that are coming before the tribal court and making decisions on behalf of the tribe. As we mentioned before, we're seeing traditional circles, such as in cake, instead of that Western model of tribal courts. And we're also seeing, of course, tribal councils acting as tribal courts. So what type of justice system may a tribe use? And this is the beauty of tribal courts. Tribes can enforce their laws through their own justice systems, meaning that they can choose to create, to implement any type of justice systems that they want. And they're not limited to one. We can have an elders panel. We can do an intertribal court. You can have a multi-judge panel. And that's the beauty of tribal court, that the possibilities are really endless. And the only requirement is that the tribe has jurisdiction and the tribal justice system provides due process. And we're going to I know that, Denise and Roxanne are great, and then all their presentations kind of touch upon due process, but those are really the only two requirements that tribes and tribal justice systems have when we're thinking about how we're going to administer the justice, how we're going to implement tribal courts. And again, turning back to the Alaska Supreme Court in John v. Baker in 99, the Alaska Supreme Court recognized that and they say it here that the due process analysis, the tribal courts are not required to use procedures that are identical to ours in their courts. So what the Supreme Court is saying is that we respect the cultural differences of tribes in the Western model, and tribal courts do not have to look anything like Western courts at all. So kind of moving on to tribal councils acting as tribal courts. So some things to consider. Again, when we think about the tribal council's authority to act as tribal courts, again, that's going to be found in the tribal constitution that gives the tribal council the authority. It gives them the jurisdiction to establish systems of justice, to administer justice within their tribes, within their villages, and that really affect their tribal citizens. So some things to consider, of course, tribal councils who are acting as tribal court judges, they're required to follow tribal law, tribal procedures, and policies. And so when we talk about tribal law, we know there is written law, we know there's unwritten law, there's customary law. Those tribal councils who are acting as tribal courts are required to follow all of that. If it's written, great. If it's not written, but it's understood within your community, they're required to follow that. So that's the first thing I wanted to mention as things to consider. The second things to consider is something that tribal councils in Alaska may not all be aware of, but there is a federal law. It's the Indian Child Protection and Family Violence Prevention Act. You'll see the citations there. But what that act requires, and this may only apply to tribal councils, it also applies to tribal judges if that's separate within your tribe. But for anyone who adjudicates or has anything to do with tribal children in the tribal courts, in your child welfare programs, in your social services, they're required to pass a background check under the Indian Child Protection and Family Violence Prevention Act. And so what that act does, excuse me, it provides minimum standards of character, and it requires that those people who have any type of authority over tribal children, that they're not, that they go through a background check, and that they can't have been found guilty of or entered a plea of no contest or guilty to any felonies or any misdemeanors under either federal law, state law, or tribal law that involves crimes of violence, sexual assault, molestation, exploitation, contact, or prostitution, crimes against persons, or offenses committed against children. And so when we think about why that is, it makes sense, right? We want to make sure that our tribal judges or the tribal council members who are acting as tribal judges, that they don't have these types of violent, sexual, really heinous crimes against tribal children when they're making decisions that really impact the lives of tribal children. And so, again, this is really important that a lot of tribal councils may not understand or know of, but we want to make sure that we're doing that background check and that we're making sure that we check for federal offenses, state offenses, and tribal offenses. And again, something else to consider, we just talked about that, that tribal courts can be set up in any manner the tribe sees fit, but that your due process rights must be protected of the parties. And the reason why is because the Indian Civil Rights Act requires that the due process rights be protected in tribal court. And so I'm sure that we all know what due process is, but it doesn't hurt to kind of review it. But at a minimum, due process requires that we provide the parties notice, we provide the parties an opportunity to be heard, and that the judges or the people who are serving as decision makers over that tribal court hearing are fair and impartial. So the part I want to focus on for today's purposes is really part 3, that fair and impartial decision makers. So the third prong of due process requires that our decision makers be fair and impartial. And those words are really kind of, they're fluffy words. We're not really sure what they mean, but at the very core level, that means that your decision makers, your tribal court judges, your tribal council members who are acting as judges, that they do not have a conflict of interest. And why that's important is because we want to make sure that if there is some type of conflict from your judges, it really kind of affects their ability to be fair. And so we want to make sure that we're protecting the rights of the parties from any type of unfair bias, unfair interest that the tribal judges, decision makers, your tribal council may have, to make sure that only that the parties to the tribal court case will have a fair chance in court, but also to make sure that we're building up the trust and respect of your tribal justice systems. I can imagine that if I, knowing Denise, if I had a case where she was a judge and I was appearing as a defendant, Denise may not be able to be exactly fair because of our relationship over the years. So we want to make sure that there are no conflicts of interest, and that we are looking to see whether or not there may be an actual conflict, meaning, let's say that I'm a judge and my fiance comes into court, well, I should step down because there's a strong personal relationship, or the appearance of, a conflict of interest. Using the example from Denise, if I'm a judge and Denise comes in my court and everyone knows of our relationship, I want to make sure that I'm going to, respect the integrity of the court to help build up that respect and that trust in the court. And I'll probably step down and let another judge hear that case. Again, the beauty of tribal courts, the beauty of tribal justice systems, that tribes get to define what constitutes a conflict of interest. And so what we're seeing across most Alaska tribes is that they have these 3 prongs to really kind of delineate or to define what is a conflict of interest. Again, a conflict of interest is some type of situation or some type of relationship that that judges will have, so they don't hear cases where they may be too close to a situation to be fair or to be considered as fair. And so some of the situations that we're seeing across tribal laws in Alaska is that they define a conflict of interest, meaning that their tribal judges, their decision makers, their tribal councils who are acting as tribal judges, they cannot hear cases that involve an immediate family member. They cannot hear cases that involve a strong personal relationship. They cannot hear cases that involve a direct financial, political, or personal interest. And so when those cases come up, those code of ethics, those conflict of interest definitions require that the judge step down and that case be given to another decision maker, another judge, or not be involved in that case. And so I wanted to kind of share a sample conflict of interest or a code of ethics. And this is from the Kenaitze Indian tribe. And so you see that they say in section G, no judge shall be involved in a case where he or she has a direct personal, political, or financial interest, defined as a possibility of a court transaction that may lead to personal gain through favors or financial or political gain. So their number 1 talks about that personal, political, or financial interest in the subject matter of the case. They also say no judge shall be involved in a case where he or she has any immediate family members that are party to the case. And they go on to define what an immediate family member is. No judge shall be involved in a case where he or she does not think that she can be fair or impartial. And I think that's really important. Oftentimes in the Denise and my example, if I can think I can still be fair, is it still okay for me to hear that case? And that's going to be a decision from your decision makers to make. And again, some of the considerations that should go into that is, not only do I have the ability myself to be fair, but if I render a decision on behalf of the parties who are appearing before me, is there going to be some type of perception within our tribal community or within the villages that maybe I shouldn't have heard that case because of my relationship? So we want to make sure that we're thinking about both actual conflicts of interest and perceived conflicts of interest, because ultimately we want to make sure that we're making decisions that are going to uplift, that are going to hold, that respect that integrity of the tribal court and justice systems. So best practices. I don't have a lot of best practices here, but the first one, of course, is what we just talked about. We always recommend that tribes developed and they institute that judges' code of ethics or conduct that really specifically defines what a conflict of interest is, and maybe goes on to state, if there's a conflict of interest, what do we expect from our tribal judges? What do we expect from our tribal council members who are acting as tribal court judges? Or what do we expect from our decision makers to do when there's a conflict of interest? Again, number two, we want to make sure that due process rights are protected. And I cannot stress that enough, because that is one of the main reasons why a tribal court decision will be overturned if someone runs to the federal courts saying that my tribal court, my rights were not protected. Due process is really important to make sure that we're doing, and it's fairly easy once you understand it and learn it, but we want to make sure the due process rights of the parties that are coming to our tribal justice systems or tribal courts are protected. My third best practice is we want to make sure we document everything. Oftentimes, we forget to document something, but when we have to go back to review a case, or if a case goes up to appeal, they're going to request a copy of what you have in your file, your court file. So we want to make sure we're documenting everything and that we're keeping our records updated and that they are confidential. And so goes on to number 4, we want to make sure we keep the confidentiality of our tribal court files. When we're writing our procedures, we're writing our laws, our processes, we're thinking about who really needs to have access to these files and only provide them access. The confidentiality also applies to tribal council members, to tribal court judges, decision makers, tribal court staff. We want to make sure that the tribal justice system, your tribal court or your tribal councils, if they're acting as tribal courts, that process is confidential to, again, to secure the integrity, the respect that your tribal council or your tribal citizens are going to give to it, and to really maintain that. I can imagine that if we went into court and then, we're shopping at AC the next day and we see the tribal judge there or the state court judge, and we hear them talking to somebody about our case, I mean, that's not going to really, gain the respect. It's not going to make me trust the court system. So we want to make sure that we're keeping that confidentiality and that what goes on in tribal court stays in tribal court. And then finally, number 5, this is really for those tribal councils who are acting as tribal courts, to have separate spaces and files. So we want to make sure that if the tribal court hearing for tribal council members who are acting as a tribal justice system or a decision maker, we want to make sure that your files, your spaces, they're separate. We want to make sure that we're restricting who has access to court files. We're making sure we protect the confidentiality of those court files, and they're not commingled or intermingled within your tribal council files. We want to make sure that if they're tribal court hearings, that it's a secure, closed-off space, that people are not going to be walking through or inadvertently opening doors coming into your tribal court if you're acting as a tribal council. So really thinking about how we can separate spaces, how we can separate documents, and again, maintaining that confidentiality to build that trust in the tribal justice and court systems is going to be super, super important. Whew. And that is all I have. Does anybody have any questions?
So I do want to let everybody know that if you're on the phone, to unmute yourself, it's *6. And if you're online, there's a microphone button at the top right-hand side of your screen. So we're completely opening the floor for any questions for Rick.
I know that was a lot of information. Any questions?
I'm just giving it a little bit of time for it to anybody to unmute themselves. If you're not used to Teams, it could take a little bit.
Okay.
Hello.
There
Are we
we
on?
go.
Hi.
I hear somebody
hear us?
online. Yes, I could hear you.
Yes. Okay. This is Native Village of Tununic.
Hi.
Thank you for joining us.
Susie has a question.
Yes, of course.
I do have a question. I think the guy, what do you do in cases if a guy is released from, we're a small enough village. The guy was released and we weren't notified, but the young parents, the young families that were victimized are walking on thin ice, because he is an adult, and I'm sure the mother that houses him doesn't keep an eye on him 24/7. And I was also concerned, what if he victimizes, having had a background of abuse of a minor, what if he victimizes other kids that are playing out?
Yeah, that's a great question. Thank you for the question. Unfortunately, I imagine that this gentleman was in state court custody or state corrections, correct?
Yes.
Yes.
Yeah. And that is, I mean, since my time at AVCP, I've been having these conversations with the Department of Public Safety. Unfortunately, the district attorney's office has the responsibility of notifying victims of any change in status. So that means that the victims to that particular case, when this person was going to be released from, from prison or from the jail, that the district attorney's office, the victim services advocates should have reached out to the victims and the parties to that case to let them know that they were being released. Unfortunately, the district attorney's office does not notify tribes when people are coming back to tribal villages, to the communities, and being reintegrated back into the community. But to answer your question, if there was a victimization of a child, I don't know if the tribe has considered utilizing the tribal justice system to get some type of protective order or not. For the child that was victimized, I think that is a definite possibility. Are there tribal police or village police, VPOs, or
Yes,
there
is, and they too were concerned when the young mothers, it's children's, not just one, there's more than 3 or 4. But the young parents, once they found out about it, I told them I told the tribal police to have them fill out protective order.
Exactly. Yep. I think that's going to be your best option, and I'm really super happy to hear that you have some type of law enforcement there. But that would be my recommendation. If something happens, to have them fill out a protective order in tribal courts, because those protective orders are required. Once they're issued by a tribal court, they're required to be enforced by the state troopers, by other tribal police, by VPSOs, by essentially all law enforcement in Alaska.
Okay.
Okay.
Thank you.
And that particular order form can be made by the local organization, right?
Yes, and I know that AVCP, the Tribal Justice Department has, they can provide you with some sample domestic violence forms, and they can also help you with technical assistance throughout that process. We are also always available to help with that process, and we can also help with registration and how to forward those off to all the different state law enforcements once you guys are issued that tribal court order.
And if we're under that regulation, in if and when a sex offender comes to our village, we will be notified, right? If
So
and when any sex offender comes in.
What
I don't believe that the state notifies. Again, this would be the district attorney's office who's required to notify victims of a state court case. They're only required to notify parties to the case or victims to the case.
And not the organization, huh?
Right, and we've been trying for years to get district attorneys to say, "Hey, we'll reach out to the tribes." Some of them do. Some of them, if they have that good relationship with tribes in their area, they will reach out. Roxanne, I'm looking at your comment. Duty to warn is sent to the tribe and council. Do you want to expand on that, Roxanne? Okay. As far as I know, the district attorney's office does all notification. I'm not sure if the adult probation office does also warn tribes and the council, but as far as I understand, the district attorney's office does not do that.
Okay. All right.
Thank you
Okay.
so much.
Of course. Any other questions?
Rick, before you hop to any other verbal questions, there was a written question in the chat. Can a tribal court take away parental rights?
Yes, I see that. Thank you for that question. They can. So I imagine, Dora, are you talking about like a child protection case where there's been a child who's been harmed or allegedly harmed by a parent? So if your court, if your tribal court, your tribal justice system, if your tribal council is acting as a tribal court, your tribe can handle those child protection cases internally. Part of those child protection cases, and let me back up. This is where the tribe either is taking custody of a child who has allegations of abuse, for the best interest of the child, or it could be, let's say that it could be a pure custody case where the dad is saying that the mom is abusing the child, and so the dad brings a case in tribal court. In both scenarios, the custody, the physical and the legal custody can be granted to one parent. If it's severe enough, and if your tribal laws or customary laws, traditional laws allow for it, they can also terminate parental rights. Those are a process, again, that to go through. We want to make sure that your due process requirements of notifying the parties has been completed, but those are certainly things within a tribe's jurisdiction, within the sovereignty that tribes can go ahead and do.
Thanks, Rick. I know that there's another question.
Yes,
Go
good
ahead, Desiree.
afternoon.
Good
I'm
afternoon.
sorry. I didn't mean to interrupt. Mr. Garcia,
Yes.
I really appreciate the rapido communication you presented. That was quite a fast pace. But I do have a comment in regards to the conflict of interest issue. I would suggest in the future for staff of its own tribal court units to develop what conflict of interest means in our Yupik native language. Our language has its own power and definitions when we're holding our courtroom versus when I speak English, it seems to weaken what I'm trying to get across. But
Yes.
when I speak in Yupik and explaining to a case in our native tongue, it's much more understood. With that being said, are we not, because it's been years that Alaska, especially in our region, some of us are in infant stages, mid stages, teen stages, and then maturity, the maturitism of some certain tribal courts. Are we not ready at this point to create and develop a intertribal memorandum of agreements and have the memorandum of agreement document presented so that we can be able to assist other tribal courts that may be facing a severe conflict of interest?
Yes, Daisy May. Thank
I'm
you for the.
I'm speaking in Yupik while I'm presenting it in English, so I hope I'm understood.
Yes, no, you're making complete sense, and thank you for mentioning that. You know, I always think it's super beneficial for Alaska tribes to write their laws in their native language as well as writing it in the English so that everybody is aware of, of what is happening. And you're right, Daisy. I don't speak Yupik, but I know from my mom being Korean and my dad being Mexican that, there are words that just don't translate into English, or when they do translate, it doesn't necessarily have the same meaning as in a native language. But I think, your intertribal court memorandum of agreement question, I think it is. I think that, when we think about something I didn't mention as far as tribal court structures is, tribes really thinking about having that appellate court structure so that any challenges to your tribe's decision will go to that appellate court. And I think that would be a great option for a regional or intertribal court, is to consider having that type of level of court, but having, a lot of tribes pool resources together, or having tribes that are a little bit more experienced, have a little bit more knowledge, create that intertribal court to assist those tribes that are just now starting or reinvigorating their tribal court, to provide that assistance, to provide that knowledge, and then once their tribal courts get established, maybe not utilizing that regional tribal court. But Daisy May, I appreciate that. I think that is a great point, and yes.
Can a court be settled in a neutral court too?
I'm sorry, I didn't I
On
think I
a
broke.
neutral court, I mean, like if the accused or a defendant wants to go to a neutral court, like not the local court here or the court where that person is from, or another court. Let's say they want to take that court to Bethel and have it settled there.
They
Can they
could.
do that?
They could, and that is going to be more of a decision of well, let me back this up. If your tribe has an agreement with a different tribe to hear cases on your behalf, then yes, that case can go to the other courts. If it is
Not their court, but like a neutral court.
they could. So if it's the tribe who is making a request for another tribe to hear the case, then yes, there can be an agreement between tribes that allows for that to happen. If a person, let's say that I come to I am a Congignet tribal citizen. I'm in court in Kong, and I say, "Hey, Kong tribal court, I don't want you to hear this. I want to take this case to Hooper Bay." It may not fit Hooper Bay's court because, again, we want to make sure there's that jurisdiction requirement that, Hooper Bay is allowed to hear cases. And so if the person who's requesting the case be transferred doesn't meet the other court's requirements, then they may not be able to hear that. Does that make sense?
Yeah, sort of like what that lady was saying, that MOEA of the
Yep.
Intertribal Court. Yeah.
Yep.
Okay.
Yeah, and a lot of courts in Alaska are using that regional court, that intertribal court, as exactly that, as a conflict court. You know, if we have a court that has one judge and that judge is hearing a case involving their family members, then that's when that intertribal or that regional court or the agreement with your neighboring tribe may come into play to hear that particular case.
Okay.
Okay.
Yeah.
Thank you for that question. That was a great question. So another question, how often do we need to have an assessment? So the assessment process, as many of you know, is done by a network of contractors who work on behalf of BIA Tribal Justice Support. Tricia Tingle's team, BIA Tribal Justice Support, they recommend that you get an assessment every 4 years. Anywhere, if you have an assessment and it's been more than 3 years, but less than 5 years, so anywhere between 3 and 5 years from your last assessment. So if your tribe had an assessment in 2018, I would definitely recommend getting another assessment done. And that'll, again, open up those doors to that assessment funding that's available, that one-time and annual funding. But yeah, I would recommend that your tribe consider submitting a request for another assessment at this time.
If that's the case, assessment will be done by the administrator, right? Or
yeah, you know, I've seen
could be filled out by the administrator.
right. So the request is
or should we fill them out too?
So the request for a tribal court assessment needs to come from someone who has authority on behalf of your tribe to request it. And so how I've seen it done by your tribal court administrator, you know, after getting approval from tribal council or talking with them about it. It sometimes comes from a tribal court clerk or tribal judge. But yeah, the request can be signed by anyone who has authority to act on behalf of the tribe. When the assessment people come in, the assessment team comes in to the tribe, they normally try to meet with council members, tribal court administrators, tribal judges. They like to make that group broad to get an overview of your tribe's justice systems as it stands right there. And then they may break off and have individual conversations with your judges, your councils if they're acting as judges. As you know, tribal court administrators to really kind of hone in on your court activities and procedures. But I know they generally like to be a little broad. And so we're seeing in the chat that for the assessments, the letter of request is done and the council president signs it. So, yep, and that would be a good example of the council being involved in that. But it's really whomever is authorized to sign those types of requests on behalf of your tribe. Any other questions? Okay, so I'm not sure if everyone can still see my screen. I think I still may be sharing, but I wanted to kind of just mention that the Alaska Native Women's Resource Center is, we're in the process of finishing a book. It's called Alaska Native Women, Ending This Violence, Reclaiming a Sacred Status. And we're really excited about this. It's going to be released in June 2023. And the focus of the book is really on, well, two things. It's the first time that an Alaska-specific book that covers domestic violence, family violence, child violence, sexual violence, gender-based violence, intimate partner violence, so all of different violences. It's the first time that an Alaska-specific book has been written. And it's the only time that we know of that it's been written by Alaska Natives. And so we have a great team here at AKNWRC. I've read through the book. It's about 200 pages, but it really is a great book that's focused on Alaska, that not only provides a lot of stories from Alaska Native women and across our state for many, many years, but it is a comprehensive evaluation of laws, of different treaties, of different decisions from courts that really affect Alaska Natives and Alaska tribes here. And so again, we're really excited about that. It's going to be coming out in June, and of course, I will keep everyone updated about it. But be on the lookout for that. And again, we'll be spreading that out once it is released. And then finally, I wanted to say thank you to everyone. Again, I'm always super excited and appreciative when, you know, AVCP asks me to come and speak to everyone here. Like I mentioned before, I have a really, you know, love for AVCP tribes in the YK region because of my time spent there. But on the screen is my information. If you have any questions at any time, please feel free to reach out to me. We're located in Fairbanks, but I'm here in Anchorage. But if I don't know the answer, I'm always gonna, you know, I'll be happy to refer you to somebody who I think will know the answer and do a warm handoff. But we are here to help, and so please, if you have any questions, please feel free to reach out at any time. Hey, Denise,
Thank
I'm going to
you,
stop
Rick.
sharing.
Yep, that's fine. So also, Rick's information was in the PDF slides that were sent to everybody who registered. If you haven't gotten them, please reach out to us. I've dropped Roxanne's contact information in the chat. Tribal Justice at AVCP is here as a resource for you as a tribe. So we also want to help you. If you don't have Rick's contact information, I'm happy to pass on any messages to him as well. We do have virtual events just like this planned throughout the year. So please keep an eye out for that information. It will be coming out pretty quickly here. But if there are no other questions for Rick, thank you everybody for joining us. And we look forward to meeting again with you.
Thank you very much.
Oh, yeah,
Thank you,
no.
everyone. Have a great
You're
day.
welcome. Have a great day,
Yep.
everyone.
Yep, have a great day too. Take us muna.